Hello, everybody. So we are live with episode 4 of our Breaking America series, and I'm lucky enough to be joined by Devin Miller. Thanks for joining, Devin.
Thanks for having me on. I'm excited to be here.
Devin, while researching this, I'm about 90% confident that you're not human. You seem to have achieved an inhuman volume of stuff on your CV, which I would love to go through. So, other than being the founder of Miller IP Law, you also host a podcast. You have a doctorate in law, a bachelor's in engineering. You speak Mandarin, and you also did an MBA. So, yeah, quite a background. So, would you give us your lead in, because I want to talk about trademark law and IP protection and really dig into what that looks like in the US. But can you just give us some background on you and what kind of took you on this journey to be as accomplished as you are today?
Yeah, and I can give you a bit of an insight, and whether or not it's a whole bunch, I just like to keep busy. And I always joke. Everybody always asks what I like to do as a hobby, and my joke is always I like to do startups. So that's kind of that would be my mantra. But yeah, to give you a bit of an introduction and background on myself. So I ended up getting 4 degrees, which my wife says is always 3 degrees too many. So I got an electrical engineering degree, a degree in Mandarin Chinese, and then I got my law degree as well as an MBA or Master's of Business Administration. So I always did that. And, I always looked at that as really, I'd like to get, if I'm already at school, why not, get dual degrees at the same time, double up as much as I can so I can come out and be as smart, at least as smart as I personally can. Doesn't mean I'm smart, but as much as I can. And then I've also done kind of over the history. So I started my first startup when I was doing my law degree and MBA degree. So you kind of talk about crazy life. At that time, I was doing my dual degrees. I was working about 20 hours as a law clerk at a law firm. And I had a 2-year-old at the time. We just had a newborn at the time. And then I decided, hey, why don't I enter into a business competition with 3 other people I never knew? Ended up entering in. We did well, decided I want to continue on. And so I actually bought them out, continued that business. It's still going today and I still enjoy it and it's a great time. So I've done several startups since then. And one of the things I'm doing now, along with everything else, is Miller IP Law, which you mentioned. Started my own patent and trademark law firm about two and a half years ago and been building that ever since.
Yeah, I mean, as you say, doing degrees for the sake of doing them sounds good. It's more the practical sense of actually getting the grades required to pass them is something else. So what was the other business you were doing? Because you do one where you help people proof of concept businesses for engineering and products. Is that right?
Yeah, so it's called Mountain Green Engineering, and it's a product development and prototyping firm. So we don't get quite into the manufacturing. We don't actually get out to mass producing it, but we'll work with people. And it kind of goes hand in glove with Miller IP Law in the sense that on the one hand, we do patents and trademarks to help people protect their ideas, protect their inventions. And then alongside of that, we have kind of more of the engineering where people can do 3D printing, prototyping, modeling designs. We can do product development. And we kind of look at those as kind of 2 heads of the same coin. So we do, on the one hand, we'll do product development and prototyping. And then the other hand, we'll do the patents and trademarks to help them to protect it, or vice versa.
Okay, that's interesting. So in one of the first episodes I did, I spoke to a guy called Dan Glazer from Wilson Sonsini, which is obviously a big Silicon Valley tech firm, and we sort of discussed the merits of getting term sheets and getting, protection when you enter the US market. Now, what he did stress was actually there are some very good local law firms that you can use. Your one being a case in point of how we started to look at IP protection, patents, trademarks, because coming from the UK, our litigation environment means that if you sort of file an infringement, a trademark infringement or an IP infringement, if you lose, you have to pay the legal fees for the person who wins. Whereas I understand in the US, you don't have to do that, and actually that's part of the litigation landscape, as it were, and can add to some of the complexities. So first and foremost, what I'd say is, what should people do? At what stage should they come to you for sort of first initial consultation?
Yeah, so maybe it'd be helpful just to set the level set is what is intellectual property, what are patents, trademarks, and copyrights, just so that people they know if they even have one, but in order to know to come to us. So, intellectual property is basically an umbrella term. So if you to think of, hey, it has multiple things under it, which are patents, trademarks, and copyrights. So patents really go towards an invention. If it does something, if it's a functionality, it's a widget, whether that's software, hardware, or mechanical or anything of that nature, that's under patents. Trademarks are going to go under brands. And so if you're anything that's a name of a company, name of a product, a catchphrase, a logo, a design, something that people associate with your brand, that's under trademarks. And copyrights are more for creatives. If you think of movies, books, paintings, sculptures, photography, anything of that nature, those are under copyrights. So kind of with that as an understanding of kind of what are those three categories, then really you got to understand where your business is at, or where the value of your business is. And so that's kind of where I always would say to start at, if you're thinking about when to approach an attorney, is figure out, are you a product brand, product company, you're making the world's best widgets, you got the next iPhone or the next whatever the widget might be, and that way you're saying, hey, now that we've put in a whole bunch of time, money, and effort to develop this, we want to make sure to protect it, that somebody else doesn't rip it off. Then you'd want to approach approach it on the patents. Trademarks are saying, hey, we are building a brand. We're going to be the next Nike or Apple or Starbucks or Amazon or whoever it might be, or Uber or whatever it might be. You're saying we really want to protect a brand. Then you're going to say, okay, that's the value of our business, and that's what we need to look into. And same thing, if you wrote a book, you've got a series, you're doing a movie or TV or or sculptures or paintings, then you can say that's the value of our business. So I would start, before you even go to an attorney or consider whether or not you need to start protecting it, is figure out what your business is and where the value is. And then really, there's two ways. One is, I would say it's never really too early to talk to an attorney or to talk to someone, because, and find a good one that will sit down with you, spend a few minutes, not charge you for it, and just give you some advice and to give you some strategy, which is what we try and do, And so we'll sit down with you free, we do free strategy meetings. We'll just sit down with you and go through it. But, easiest answer is it's never too early to dive into it, or at least get a strategy. And sometimes the answer may be you're too early, or you're way too late, or anything or all the above, but you can at least get a feel for what you should be considering.
So I was going to say, on behalf of the client, then they approach you and say, look, hey, I've got an idea. What would you then do? Let's say it is reasonably complex. You don't have an innate knowledge of that market. You then go and conduct a search on their behalf to just see what's currently out there.
So I'm going to answer your question, but let me give you one other caveat just to give people a frame of mind as far as timing. So let's say you did have an invention. Yeah, the world's greatest widget. You build the next iPhone, and it's going to kill the market. It's going to make it revolutionize it. What two timelines you're going to want to think on patents is, one is the earliest you can approach a patent attorney, or you should, as far as if you want to get an invention, is you have to do what's called conceptual reduction of practice. Now, what does that mean? That basically means you can describe your invention to a level of detail that somebody else in the industry, somebody else that works, in that industry, would be able to understand it and be able to replicate it. They don't actually have to build it, but you could explain it to that level. So that's kind of the earliest. The latest is going to be, what you want to avoid is whenever you put something out in the public, whether it's, presentations, you're selling it, you're pitching it, you're putting up a website, you have a year from the earliest time you put it out into the public within which you can file a patent application on. So you don't want to wait too long to file on it or to get going on it. Now, you ask kind of the process. Let's say you come in and you're fit within that window and you said, I got this great invention. It's going to change the world. And that's what all great inventors think, is everybody's invention is going to change the world. Some do, some don't. But, you come in and you ask on patent search, and, one thing that we try and do is tailor it a bit to where a business is at. So sometimes you'll do a patent search and sometimes you won't. Let me give you kind of an examples of when you might think about it. So let's say you have a great idea, but you really don't know what else is out there. You don't know what others have done. You don't know if it's really patentable or if somebody's already done it. You're trying to get a feel for the landscape. Then I would absolutely recommend a patent search. Then we'll go out, we'll do a search, we'll get an idea of what else has already been invented, how crowded the space is, what you're likely going to face during the prosecution phase or the examination phase of your patent, and we'll do that search. And it's not a guarantee, doesn't let you know every possibility, but it gives you a much better of an idea. On the flip side, let's say you are an expert in your field, right? You know what everybody else is doing. You're very on top of it. You're cutting edge. Then you may not need a patent search because you probably know your industry honestly better than us. You know what all the players are doing and what's already been done. Then it maybe doesn't make sense to spend the money on the patent search and you just go right for a patent application. So it kind of depends on where you're at. It also depends on your budget, right? If you don't have the money to do both a patent search and do a patent application, then you're going to have to say, we may just have to wing it, kind of hope that what else is out there because we'd like to get this secured. We'd like to make sure that we get that date of invention, and then hopefully we're patentable or we're as unique as we can. And sometimes the budget always plays into it.
In terms of the art of explaining and describing the patent to the sort of level of rigor required, what will you do with the client to sort of come up with that wording and make sure it's protected, and how sufficiently protected does it need to be in terms of how generalist can the description be versus how siloed do you need to, and specific do you need to be?
Yeah, so the very most general or basic answer is give your attorney as much information about your widget as possible. In the sense, it's always easier to scale back or to have too much information and not include all of it versus having that information, not giving it to your attorney. We never include it, and then you limit the scope or the scope of your patent application, how much coverage you get. So that's a general answer. Now, as far as kind of, there is almost, when you get into patents, there's almost kind of that legalese, right? Or lawyers speak that everybody else reads this as, I don't know what it's saying, but it sounds good to me type of a thing. And really what we do is, and generally most attorneys will do something similar is, we'll have you, if you were to come in and say, hey, I want to get started, we set you up as a client, then there's a form and it kind of walks you through, here's the information we'll need, and just write it, how you understand it. And you can explain, hey, this is what others have done. This is what we're doing differently, what we think is unique about us. Here are the details of how it works. Here's maybe some hand sketches or drawings. Here's maybe a video if you have a prototype, and you kind of provide that information. And then we comb through it and we kind of look over it, get prepared, and then we do what's called an invention disclosure meeting. It's about a half an hour to an hour meeting where we go through and chat with you on all the details of your invention. How does it work? If you were to somebody to pay you to design around your invention, how would you do it? What is the different ways you do it? Let's say now we reach out, what is generation 2 or 3 of your product? And we kind of go through and go through that and get all that information. We take all of that and then we draft the application based on all of that. And so that way we can kind of culminate it. And then, client gets to review it, make sure they think, hey, this looks good, covers everything, and then we file it. That's kind of the general process.
Okay. And do you have relationships with the people that, or the body that you file it to, so you can communicate back with them and ask them prior to sort of a formal submission if you think there's anything wrong with it, or is it just a blind submission to a sort of governing body?
Yeah. So as far as the initial submission, they don't give you any kind of hints or, kind of initial review. They just, once we prepare, we file, once it's prepared, it's approved, it gets filed. And when you file it, you really get, you get put in a queue for examination. So I guess a couple things happen. One is they define your date of invention, and that's the date that you file it. As far as the government's concerned, the day that you file it is the day that you invented it. And so anybody that was previous to that, they invented those things before you. Anybody that comes along after and copies your invention or otherwise comes up with the same inventions, you own the first rights because you have that earlier date of invention. But that also means you're patent pending, right? That's kind of what it means when you're patent pending is, hey, we filed the patent application, we got our date of invention, we're going through the process, we believe that we're going to get a patent and we own the rights to this invention. Now, once you file it, it gets put in the queue for that examination. And it really takes, at least in the U.S., and I'm speaking off the U.S., not off the U.K. or other places because they all vary a bit, but in the U.S., it takes about 12 to 18 months to get to the top of the queue. You can pay expedited fees, get it to the top of the queue more quickly, but that does cost a decent amount of additional fees to do that. So generally 12 to 18 months. When it gets to the top of the queue, they really look at it, and they're going to look at it for kind of 3 primary standards. So the one standard they're going to look at is novelty. Novelty is basically, has anybody else already previously invented this? If they have, you can't get a patent on something that somebody else has already invented. It's already been invented, and therefore you're not the original inventor. Second thing they're going to look at is obviousness. And obviousness kind of has a couple different meanings. One of the meanings is obviousness is, hey, not one person has invented this, but if you were to take 2 or more things already out there, already in the industry, put them together, you're really not doing anything unique or novel. You're just taking 2 or things out there, putting it together in an obvious way and doing that. Or you can, the other kind of definition of obviousness is, hey, not one person, nobody has invented this, but you're really just doing an obvious tweak of what's already out there. So let's say that all cars used to be black and now you changed it to blue, and nobody's ever done a blue car before. Well, it's not really that, inventive or unique. You just change the color. And just because nobody has done it in that specific color doesn't mean you really invented anything new. So that's kind of obviousness. The last thing they're going to look at is what's called an abstract. And they're going to say, what you can't do, you can't just take something that people have done in their heads for a long, done in their heads before with a pen and paper and stick it on a computer and call it new and make it patentable. So you couldn't take 2 + 2 = 4, say, now I'm going to have a computer do it. It's the exact same thing people have already done, but I'm going to get a patent on it. So nobody else can do 2 + 2 = 4 on a computer. You can't do that because it's too abstract. And you would have to say, we've got to add something more. It has to be something that's not just sticking something that everybody's already done on a computer, but it has that uniqueness, that difference that is something that's inventive. So those are kind of the process. They'll look through it. They'll either determine, yes, it's patentable, or no, it's not. And they'll either say, yep, it's patentable, we allow it. If not, then you get to go back and forth. That's where the attorneys come in. We argue on your behalf. They're going to say, hey, we're going to change the scope. Maybe we claimed it too broad. We claimed every sort of vehicle out there, whether it's a bicycle, a car, a truck, or an airplane. That was all in our patent. Probably too broad. So we narrow it a bit and say, okay, we're really only patenting cars. And so now we have a patent. We don't claim bikes. We don't claim airplanes, but we claim cars. And so you'll kind of have that give and take, and you'll either convince the examiner based on your arguments and you're changing in the scope, or you won't. And if you don't, it goes abandoned. If you convince him, then it gets allowed. So I know that was a short answer, and it was a much longer, or a short question, and it was a much longer answer. But that kind of gives you kind of an overview of the process.
No, that's really great. And actually, it informed another question that I wanted to ask, which is it more difficult to start looking into patterns behind software, for instance, than it is physical product? Because as you sort of alluded to with moving processes into the computer, or whether it's applications of AI or big data, how easy are those to start securing patents on versus typical products and inventions?
Yeah, I mean, every patent can be difficult or it can be easy. So, I'll give you the standard lawyer answers, which is it depends. If you ever want to know if you have a good attorney, if their answer is it depends, they're a great attorney. No, but is software can be difficult. But so can everything else. So I'll give you another area that you would say, oh, that should be easy. Golf clubs. Golf clubs are very difficult to get a patent on. And really the easy answer is because you've had every doctor, every lawyer, every other person that likes to go out and golf that has a bit of expendable income. And they're basically going to say, oh, I've come up with the next great golf club and I want to get a patent on it. And so they go and file. So golf clubs are a very difficult area in order to be able to go and get a patent on, even though they're very mechanical and very physical because there's just so many patents on them. Vice versa. Software can be, we work with a lot of augmented reality, virtual reality, and that one is certainly something that you can't just do in your head. You can't, but it's very software heavy, right? And so you can get, that one, it's not any more difficult than other areas to do an augmented or a virtual reality, even though it's in the software. So it kind of depends a bit on where you're at. Now, one of the areas that's very difficult in the software area is the financial services industry. Done it. We have clients that are in that and we can get them patents on it. But generally, that's almost kind of where you get into that 2 + 2 = 4. Hey, we've always traded this way, and doing a slight variation on a computer, it just makes it difficult. So there are some areas of software that are more difficult that you have to put in more thought, time, and effort and really drill down on. But I think if you have a good attorney, this certainly is a fruitful area that a lot of people are still getting patents in.
Well, and to some degree, I imagine when you talk about like the black box trading algorithms and the sort of proprietary nature of some of these systems, I imagine it's almost quite difficult to work out how you get the essence out of the banks or all the information out of the banks to basically work out where the boundaries on this sit, because they're obviously developing tools internally all the time where you have their own dev teams who are constantly refining the models and the mathematics of how they trade, etc. So I imagine it's quite difficult to compete with that.
Yeah, I mean, I don't know. Some of the coolest inventions come from the small businesses, the startups, and the ones that they don't have all the funding, they don't have all the things. I love that when you get a startup, because part of the problem is when you get a bigger business is you kind of get a lot more bureaucracy. They get a lot more risk averse, right? They now have a lot of money and they don't want to lose that money. And so you got more bureaucracy, you got more things. And a lot of times the startups and the small businesses, the ones that have that little nugget of an idea that's just really cool, are the ones that are able to really come up with something innovative, something different. And so, it really just depends. But as much I love the startups and small businesses, I'll give you one, just, kind of a complete aside, but this is just a fun one. So I'll ask you a question, since you have been asking me all the questions, see if you can guess.
Yeah.
Clothing, so jeans, right? Blue jeans, you wear jeans for clothing, right? What do you think one of the first patents on that one was?
The weave of the fabric.
So you'd be wrong, but it's a good guess. No, one of the fun things is, one of the first jeans, you wear clothing, it's a little rivet that goes on the pocket. It's simple. You think, nobody even thinks of that. But let me give you the reason why they came up with that and then why they patented it. So originally, when they made blue jeans, back in the 1800s, they just stitched them all, right? And the problem is on the pockets, people kept putting things in pockets. They put their hands in it, and the stitching would be the weak spot. So pockets would always flap open, and it would, they would look unsightly and they would wear out quickly. And so it created a problem. And honestly, you had a guy that he was doing a lot of stitching. He was doing it for different pants. He was doing it for, wagon covers and blankets and all those other things. And he had a person come into his office and say, hey, my husband needs a new pair of jeans. I hate the pockets always wearing out. Can't you do anything to make them better? And he looked and, gave us some thought, and he was also doing horse blankets. And at the time, they used metal rivets on horse blankets to make them tougher. And he says, well, why don't I do this on pants pockets? It's going to have the same effect. And that's where they came. And that was a guy that just came, and then, that evolved into, he went and sold it to Lee Jeans, which is one of the major brands. And, that evolved into what Lee is today. But that's a really simple thing that, you don't really think about, and yet it has a big impact. And so when you say, hey, is it favor big businesses or startups? It can come from anywhere.
Well, quite. And so actually to this point, what's the lifetime of a typical patent, or do you choose that on behalf of the client, or is there a standard length of period?
Yeah. So every country is different. Now within the US, basically you have 20 years from the date you file your patent application. So whenever that date of that original filing is, you have 20 years from that date. After that 20 years goes by, then it becomes public domain. It means anybody can build on it. So really the way that they set up most patent systems in most countries is they're saying, hey, we're going to have a trade-off in exchange for you disclosing the details of your invention, how it works, giving that, providing that information to the public such that people can build on it, that they can, improve on it, and they can make things more out of it. Then we'll give you a monopoly. We'll give you that exclusive rights for those 20 years. After the 20 years expires, anybody can build it, anybody can make it, and it's kind of that trade-off or that exchange that you'll get an exclusivity for a period of time in exchange for giving people that information. And that's why a lot of times it's kind of one of the examples, aspirin and other, after a while, you'll see generic drugs, right? Aspirin or Tylenol, you can always go to the store and buy the no-name brands, and that's because originally they patented it. They went after it went after 20 years, then anybody can start making aspirin or Tylenol or anything else. And so now that's where you get the generic brands. And so that's kind of that trade-off.
Is there anything that a patent lawyer could do to look at that eventual, let's say it was touchscreen technology, and you thought, oh my God, this is like completely world changing, and you think the patent will end in 20 years time. Is there any way we can then deploy a second patent after 20 years with a few minor adjustments to basically give us coverage again? Or is that not really doable?
Yes and no. So you can't extend one. So let's say you came up with the best way to do a touchscreen, and really it's the best way. That's how everybody's going to do it. And for the next 100 years, that's how everybody's going to do it. Whatever was in that original patent, that becomes public domain. You're not able to extend it. Now, what really happens in the real world is that most businesses, you're going to continue to innovate, right? You're going to make it better. You're going to make it more efficient. So maybe the original touchscreen had a lag in it, and it sensed where your finger is at, but it took a couple seconds, and so it was really slow, and you couldn't use it very well. And then in 5 years, you figure out, hey, this is how we can make it faster. We can make it better, so it doesn't have that lag, so it's more responsive. You can file the patent now on that, how you made it better, how you made it more responsive, and how you made it updated it. Those additional follow-on innovations you can actually patent, and that's how you kind of tend to extend it. So that fundamental, whatever you file, once it goes 20 years, everybody can use it, but you can continue to innovate, make it better, and those improvements that give you that competitive edge, you can continue to file patents on.
Okay, and just diverting into, let's say, the commercials of this. So somebody will spend a set amount of money with you to secure the patent. What is the typical uplift in value to the applicant upon receiving a successful patent? So, because what I guess we see is investors will go, what's the IP of this company and is it protected? Da, da, da. And then I guess in the event that the company wound down or was unsuccessful, they can then sell on the patents, or they can then commercialize the IP. So in terms of that relationship of how much they pay you versus how much it's worth to them if they successfully secure a valid, valuable patent, what would that be?
Again, I'm going to give you the it depends answer. So no, what is a patent, or how do you value? So I'm going to dispel a myth, which is, too often or frequently, I don't know how too often, but frequently people will come into into my office, or I'll do a Zoom meeting or call with them, and they'll say, I got the world's best idea. It's going to change the world. All I need to do is get a patent on it, and then I'll license it. And, everybody will be knocking down my door, and I'll just be rich. And all I need is a patent on it, and then I'll stop there. And a less scrupulous attorney or someone that just wants to take your money will say, great, let's get a patent for you. But if you were to really look at it, a patent, you have to add value. A patent can be valuable, but it's not going to build a business on its own, right? You have to be able to go out and prove it in the marketplace. You have to actually get it out there. I mean, you can't just simply get a patent on it, sit on your laurels, wait for people to knock down your door and say they want to buy it for you, because 99.9% of the time that doesn't happen. Now, can patents be absolutely an asset and be valuable to a company? Sure, absolutely. So, and the reason a lot of times you're going to look at it is, what happens is, as a business or as a company, as you're creating the next best widget, the next best invention, you put in a ton of time, sweat, and tears and effort to do the R&D, to do the research and development, to figure out how it works and everything else. And then, once you figure it out, it's easy to reverse engineer, right? It's a lot of times once you say, oh, that's a great idea, and I can open it up and I can figure out how it works, and everybody else can come along after. But it's that first person that really creates it that is going to do it. So one, you have to come up with a good idea, and then you want to capture all that, capture their ability to have exclusivity once you put in all that effort. But then you need to build a company around the business. You need to actually get it out in the marketplace. You need to build that traction. You need to build that brand, and you actually need to provide that value. If you do that, I've seen patents that are worth 20 or 30,000. I've seen them that are worth sometimes millions, or even up in the words of the billions, depending on how valuable that technology is that it protects. And so it's really just varies quite a bit, industry to industry, patent to patent, how much you build a company around it, how much you actually do with that business or with that idea, as to how valuable you make your patent. So it's kind of one of those things. The patent goes up and down in value associated with the value of your business.
I would completely agree with that in terms of the startups we see. As you say, if there's no commercial application, everybody's got an idea that can change the world. And sometimes securing that patent too early is a little bit like buying all the stationery before you've actually started to sell the product, right? It's just overkill. Is there anything that would be going around of people looking at the sort of graveyard of patents and thinking where the opportunity lies amongst that? Because obviously each year there's a load of companies that are failing, a load of patents are be put back out onto the market, I assume, or does the coverage still protect them even if the company stops trading?
Yeah, so I think your question was, if let's say your company is failing, or let's say it's going under, is there value to patents? Yeah, there's still some value. So, a lot of times, first of all, let's take the flip side. When you're getting your company up and running and you don't have your, all of that traction, and you're just trying to get it up and going, investors will a lot of times look at it and say, okay, you're not cash flow positive. What am I investing in, or how can I secure my investment? And that will be a lot of times they'll look at what intellectual property you have. Do you have patents or trademarks, or what is your strategy? And it's an investable, tangible asset that they can say, hey, if this company goes under, if the startup doesn't make it, then I have this asset that then we can go leverage. We can either sell it off to other businesses that it may be valuable to, or we can incorporate it into what we're doing. So in that sense, either when you're getting going, you can use it as a tangible asset, or sometimes if the business doesn't wind down, you can also sell it off as an asset. And that happens both ways. To give you an example, so Kodak, maybe people don't remember it anymore because it's been enough time, but for a long period of time, it was, cameras, photography, film, and everything else. and they had a treasure trove of patents because they'd been doing it since 1800s, but they continued to innovate. And yet now Kodak went bankrupt. And so one of the things is they were going through bankruptcy, that they had all these patents that were valuable. And now all the other competitors that are making, whether it's, Apple that has cameras and lenses, or it's other camera makers, or it's other digital cameras and all those things, they all looked at it and said, hey, these have values. And then, as part of bankruptcy, the bankruptcy court has you sell those off. And then people come in, they bid on them, they purchase them, and they have value. So I think that they can create value on both ends, even without doing the business, if they're valuable. But generally the best value you get for them is when you actually build a business around them.
And do you get involved in protecting patents on behalf of your clients? So once they're established, if somebody infringes upon them, would you handle the ensuing litigation around that?
So I'll split the question. Me personally, no. My law firm, yes. So
Gotcha.
In the sense, and generally most of the time, with rare exception, patent attorneys kind of split into two different types of animals. One is more on the prosecution side, the drafting, the preparing, going through the process at the Patent and Trademark Office to get the patent. And that's really kind of one specialties or expertise and skill set that takes a lot of time and effort to really craft. On the other hand, the litigation, the enforcement, the going in front of the judge, convincing a jury, doing all of the evidentiary things and going through the courts, that's almost a different skill set. So we have a litigator at our firm that does a great job, that we have him kind of handle those matters and supervise and kind of manage. And then I'm much more on the prosecution of getting and securing the initial patents and trademarks. So yes, in that sense, we do it. Me personally, I don't do it as much. I get involved as I need to, but I don't dive into it nearly as deep.
And is trademarking a different skill practice to doing patents, in terms of, is it harder to convince people that your brand can be explained in a way that it shouldn't be copied, whether somebody chooses to use the same font or the same color scheme?
Well, I'll answer your question with a question. But no, so when I say M&M, when I say Pepsi, when I say Coke, when I say Apple, when I say Starbucks, when I say Ford, when I say Chevy, those are obviously brands that you recognize, right? They're ones that have that inherent value because everybody knows that brand. And yet, whether or not they have patents and whether or not they have technology, Starbucks, if you're to take them as an example, they don't necessarily have anything that's patentable, right? They make coffee, they make donuts, they make, muffins and that, but so does a whole bunch of bakeries. And what makes them different? It's that brand. So the brands are such that brands protected value. You have to build that brand around it. And then the trademarks are going to help protect that so people don't knock it off or they don't make a variation. So even more so than patents, because patents are at least on a technology, right? A functionality, and they have something that they're protecting. Brands are really what you make of them. You have to build a brand. You have to build that. And if all you do is just have a trademark, but you never build a brand, they have virtually no value. And yet, if you take all the examples, the Amazon, the Intel, the Red Hat, the Ford, the Chevy, the M&Ms, they have tremendous value and they can hold a lot. So it's kind of depends on whatever you build into your brand. Trademarks can be very valuable, or they can have no value at all.
And actually, just to give you a boost, your former work was with clients like Amazon and people like that, wasn't it?
Yeah. So now I've started my own firm, and so giving a bit of my history, I worked after I graduated from school. In addition to running all my startups, was really one full-time job. I also worked for some of the largest law firms in the U.S. Top 100 law firms, and I would work with some of the big brands. So I worked with Amazon.com, I worked with Intel, I worked with Ford, I worked with Red Hat, and several other ones. And so I did a ton of their work, and so they certainly see the value both in patents and trademarks, and they do a lot with them. Now, why did I shift? Now I don't work with those brands. I did before, and really it was because, when I was looking at it, I would say, what are the ones that are really just fun to work with? What are the clients that I love when they walk through the door and they're just exciting? And, when I do the big companies, it was cool to see, hey, I worked on one of the patents I worked on with Amazon was the Kindle. And it was cool to see, hey, when the Kindle came out to market, I can say, oh, I worked on that. And I remember doing this very small piece of that cool product. But it was, again, there was that small piece because there's a lot of patents that went involved with it. A lot of people touched it. And it wasn't like I had a big impact on it, but it was cool to see it. vice versa. When I had the startups and the small businesses, they kind of had we're going to shoot for the moon. We're going to make a big go of it. And we need someone that comes in that helps us, that walks us through the process, gets us involved. And so when I said, hey, I'm going to start my own law firm, I said, I really want to focus on the startups, the small businesses, because one, they're just fun to work with. They have really cool ideas. But two, you feel like you can have a lot bigger impact on it. You really get it down into the weeds with them, help them to figure out what to patent, what to trademark, what is valuable, what isn't, and kind of have that much more intricate role as opposed to just a very small cog in a big wheel.
And because your approach with your law firm, from my understanding, is to make it a bit more friendly faced, a little less corporate, and maybe more accessible to these early stage companies, right? That's the manifesto.
Hey, manifesto, mantra, theme, whatever it is, that's exactly. And really, when I spun out, I said, first of all, I started Miller IP. I said, what do I hate about law firms, and what do clients hate about law firms? And one of the things that everybody hated was industry average. If you reach out to a patent or a trademark attorney or any attorney across the legal industry, it takes 3 to 5 days for them to even respond to you. Meaning, if the email, a call, text, whatever it is, it takes 3 to 5 days to hear back. And I'm saying, so I can call them on Monday and I might not hear back to them until Friday or the next Monday. That's a long time to wait to even say, I want to give you your money. I want to get going. And so that was one of the things that we said, let's fix that. Let's take it. And so when I set it up, I said, hey, 80% of the time, most of the time, we pick up the phone right away. We respond to the email right away. If not, we have a rule that 90% of the time we respond within 30 minutes. And I have a drop dead, hard, fast rule that within 24 hours, we always respond. So that was just kind of one example. But then I said, what's another thing that people hate about attorneys? Well, they always hate that they feel like every time they ask a question, every time they walk in the door, every time they send an email, they're going to see it come up. And I had a 5-minute conversation with an attorney, and I see on my bill that they charged me for a half an hour. They always round up. And I said, we're not going to charge just to answer questions. If you need some free advice, if you have a question, we're just going to be here to help you out and to make sure you understand what's going on. Now, if you want to do a patent or a trademark, we are going to charge you. We do have to stay in business, but we wanted to be fair and say, before you get going, let's see if you actually need this, answer your questions. And we've really kind of taken that mantra is, the question I always ask myself is a legal industry doing this because it makes sense, or are they doing it because it's how it's always been done? If it makes sense to me, we'll keep doing it and we'll incorporate it into our business. If it's just how it's always been done and that's how people have been doing it for whatever, but it doesn't make sense, then that's where our opportunity lies. That's what we're going to improve. We're going to make it better such that then we're able to be different than what else is out there. So that was another long answer to a short question, but yeah, that would be our mantra.
And do you see a way for modern tools and technology to infiltrate the patent trademarking process, whether it be kind of, I don't know, like, is there reproducible work which could be automated via
so you're hitting on what we're working on right now. So that's a great question. So one of the things, I don't know that at least the state of technology is ever truly going to replace an attorney. Maybe when, Terminator takes place and AI is everywhere and everybody, you can replicate a human, sure, at some point, but that's not where the technology is at today. But that being said, it doesn't mean that you're not able to help people out or be able to do something of the nature of going to build some tools that allow those that can't afford it or that aren't able to get going today to do that. So backing up, what do we do? Well, we've kind of looked at it and said, are there ways that we can help those that can't afford our services, that can't afford an attorney, but are still needing a patent or a trademark? Can we build some tools that they can at least get something in place? May not be as good as a patent or a trademark attorney, may not be able, quite to the same level, but it still is going to be much more helpful. It's going to be beneficial, and they'll be able to get something in place. And that's the tools that we started to build. So as an example, we're getting ready to launch in about a week a tool that walks people through, and it's kind of a course or kind of, ability to walk through. Here are the things you need to do to identify what you need for a trademark. Here's how you file it yourself. We still recommend an attorney, but if you don't have that capability or those funds, this is a tool that at least gets you a trademark, walks you through, and gets you something in place to help you on that way. And then as you get more money, as a business starts to take off and work better, then you can always build it, make it better. You can come back to us and actually build that as a team. So we're kind of building those tools and looking, hey, what can we help startups and small businesses with that aren't able to afford attorney services and aren't able to afford what we can do? And then let's build those tools. So we built out ones that are for for LLC formations, for NDAs. We're getting ready to release one for trademarks. And then within the next couple months, we'll be getting ready to release one for patents. So I think there's a place for them. I still recommend going to an attorney if you have the budget, because I think that gives you your best value. But I also recognize that startups always have more things to spend money on than money to spend, and let's give them some tools so that as they're growing and as they're before they have those budgets to go to an attorney, that they can still get something in place.
I would agree as well, because there's a company here called Seed Legals, which is, I guess, is like a term sheet automation platform for startups. Now, they recommend that, again, at the end of that, you still have a lawyer that you can speak to, just to make sure, more often than not, that strategically speaking, you're on point and just getting the final check off. But like, there is a significant majority of the term sheet building, which they call sort of standardized, especially when you're talking about seed stage startups. Like, often you don't need to make the terms any more complex than sort of is necessary. So in terms of how you've grown your law firm, was that similar to how you've grown your previous businesses, in terms of, it seems like you have a mindset of looking at the status quo and the sort of doing the Elon Musk thing of saying, can you get a 10x reduction on this, or can you hit kind of a ground zero or a sort of a first principles thinking?
Yeah, I mean, I think every business, there's commonalities and they're different. So every business I build is his own animal. It's his own, you can't approach everything the exact same way. But I think, kind of to your point of the Elon Musk is a good example. He built space shuttles. He also built Tesla. He also built a boring company that does tunnels underground. None of all those technologies, and he also built a solar business. None of those technologies are the same technology. They don't have the same customers. They don't have the same technology. You don't have the same type of employees or engineers. But I think he, and if I were to use him as an example, takes and says, now I can do this better. How can we improve this? Or how can we shake up the status quo? And to that point, yeah, I kind of take that with a lot of the businesses. I'm saying, what are the things or the businesses that are just doing it because it's been done for forever. It's been done a certain way. Everybody thinks that that's the way to do it. And some of the businesses, sometimes that's true for a business, and those ones I stay away from because I can't add any value. But if I look at, as an example, the legal industry, or I've done a company that's in the wearables industry, or I've done one in the software industries, and I said, some of these just aren't very good, and I think I can do it better, and I think we can do it differently to add that value, to make that difference. And then I'll take that approach of, can we do something that's different, improves on it, makes it unique, makes it better, and then we kind of take that commonality between the businesses in order to build them and to grow them.
And obviously, with that many businesses spread yourself across, do you sort of solve for redundancy, e.g. trying to manage yourself out of the business through processes and just launching the idea and then getting the team in to implement and execute?
Yeah, no, absolutely. There's, I only have so many hours in the day, just like everybody else. And so, it's, to some degree, I look at it as, when I'm building a business, wherever my expertise or wherever I can add value, that, I can do something that somebody else can't do, that's where I focus my time and attention. And if I can bring other people onto the team that can do the things that either A, I don't like doing, or I don't want to do, that's the easy ones to offload, or B, that that there are people that, hey, I love to do this, but so there are other people that I can hire that can also do this, that will do a great job. Then I say, let's build that team, let's build them on, and let me focus on the areas that I really think I can add that unique value or that difference. And that's where I focus my time. So that way I can kind of juggle the different businesses, building a strong team to offload everything I can't, or they can do that I don't need to do, and focusing on where I really can do something different.
And so, in terms of, I guess, to bring it back to Miller IP, what's the dream scenario of where you see yourself growing in the next sort of decade, 5-10 years?
Yeah, that is a great question. It's a hard one, because not that I haven't given it a lot of thought, because the standard answer is, let's grow it as big as I can. We'll make it, bring on as many attorneys, we'll make it a nationwide firm. It'll just have it more. I don't know if I quite want that, in the sense that when you build a business to a certain size and you have so many attorneys, it changes the business. It loses some of that fun, some of that, hey, this is a startup feel, we're doing things differently. And you kind of become the businesses that I used to not want to work for, in the sense you got a whole bunch of cogs, there's a lot of bureaucracy, there's a lot of things that aren't fun, that then slow down the business and make you a monolith, and you're not flexible. So when I look at kind of where I want to build Miller IP Law, I don't know from a, hey, we want to make this much revenue, or we want to make this much money, or we want to have these many employees. That's less of important to me. It's more of, hey, where do I want to build it to the company so I still enjoy being in? So if it's, hey, if we want to bring on some additional attorneys, then let's keep it as this is that startup, that small business, that dynamic thing. And I focus more on, hey, where do I think that the opportunities are? Kind of as we talked about, hey, let's build those DIY tools that allow others to do it. We'll expand in that area. And if we need to build those, bring on that people onto the team in order to build that, then we'll do that. And so me, it's more of, hey, where do I see the opportunities? And I'm going to start building into the, the next 5 or 10 years. One of the things that I think is going to be where I see the legal industry going is it's becoming more and more of a commodity. You'd mentioned, kind of in the US, there's a LegalZoom, there's other ones out there. And more people are figuring out how to leverage technology in the legal industry. Now, a lot of people aren't. A lot of law firms want to stick to the old model that's always worked. But if I say, where is that next, 5 or 10 years going for the legal industry, it is really figuring out how to, whether it's automate things, make things more efficient, utilize technology, and do those type of things. So that's kind of where I see the firm going in the next 5 or 10 years, as less on how big it is or how many employees or what the revenue is, but more or less put it in the direction of where I think the legal industry is going.
Well, and I wasn't going to press you on this, but I kind of feel like you'll have a good answer in terms of the technology that excites you that you might be working on in the next 3 to 5 years. Do you have any sort of hopes of ideal clients or where you see some really exciting emerging fields appearing?
Yeah. So, and it's probably a self-biased answer because there's a lot. I love all inventions. I like my clients all the same. No, I do have favorite clients. One of the fun ones, I love AR and VR, augmented reality and virtual reality. I think that one is still an evolving field. It hasn't figured out what it wants to be when it grows up, so to speak. In the sense, there's a lot of cool technology, but it's still a lot of that technology is figuring out how we can actually make it profitable. How can we make products out of this? And I think that's an up and coming one, but I think it still has some evolution or things to evolve. Same thing a little bit, I think, with the wearables industry, in the sense that, you do have Apple iWatch out there, Apple Watch, you have a Fitbit, but I look at Fitbit, and really, if I were to look at their products for the last 5 years, they basically sold the same thing. They make it a little bit newer, put a different screen on it, change the colors or the form factor. But what's the difference between the Fitbit you bought 5 years ago and what the Fitbit you bought today? Not a whole lot. But I do think that is an industry. I just find it really exciting and fun because there are so many things that you can do in the wearables of medical and helping people to monitor their medical devices. And you can do it on, you can anticipate whether or not they're going to get sick, or, even take COVID that we're dealing with now. And maybe you can have early identifiers or cancer. And there's just so many things that are, I think, really cool. I think the wearables kind of is still evolving, figuring out what it wants to be when it grows up, that has a kind of thing. So those are a couple ones that just get me excited. Anything in the medical industry, anything in the sensor and technology industry, and kind of the augmented and virtual reality. Those are some really cool ones. There's a lot of them. It's hard to just say what are a few favorites, but I think those are some really good ones.
It's quite interesting you say that as well, because Apple, to me, is, the hardware, apart from an improving camera, seems to have reached not a ceiling in its potential. It'll keep growing, but it seems that Apple are eyeing up health and AR as their sort of landscapes of the future that they're going to try and be competitive on. And I think the issue I have with AR is that it's really exciting technology, but the problem is it still keeps we're getting sold it in silos. So you may have limited applications of it. And, you almost imagine like a company like WeChat rolling AR across its user base for a completely integrated experience where it's reliable across many different use cases, as opposed to just going, here's a game where I'm using AR, here's somebody who's a building manager checking building notes on a construction site using AR. But it needs that kind of that meta layer or that unifying use case for people to start mainstreaming it, basically. I think is a slight issue I have with it, because I think it's potentially hugely exciting in terms of it puts an information layer on the world that's accessible to you by your phone, which is great. But it can't just be that I go to a museum and can use it in one use case and then just don't think about it until I go to another museum again or download a new app, for instance. And that's where it feels a little limited to me, at least.
Yeah, no, I agree. And I think, there's a ton of cool, you could do it in classrooms, and especially as a lot of classrooms are moving virtual, that has a great potential. You can do it for employee training and how they figure out how to learn new skills. You can do it for soldiers in warfare. You can do it for, hospitals and for saving lives and doing different things. You can do it for gaming, and there's so many things. But to your point, it's kind of all dispersed, right? You kind of have different players in each of the field, and you're going to have some people that make a unified or kind of that platform technology or an ability to aggregate it together, that I think is what the industry, to make it really boom, is lacking. But I think that it's going to come along, but it's going to have to take some people to continue to push it, continue to actually build it out such that it takes a more of a mainstay as opposed to kind of siloed or novelties within different industries.
I mean, it's really great to hear how passionate you are, because I say there's some people who do it for the job, and there's some people who do it for the startups and to kind of stay on top of it. So to kind of bring anybody who's watching it who is a startup back on track, if they're approaching you, what are your entry level packs for them to start engaging? So you obviously can have a phone conversation for free, but like what kind of prices would they expect on a sort of very basic pattern process with you, so they can kind of start thinking about how they allocate resources for it?
Yeah, so I'll give myself plug just for the half a second. Yep. So if they do want to do a strategy meeting with me, they want to reach out, and they at least want to figure out where to go. Easiest way is to go to freestrategymeeting.com. That links to my calendar. We'll have a chat. So that's an easy way, at least to get you started, to answer your questions. Now, if you're saying, hey, what is the cost? Generally, if you're looking at patents, you can have a couple things. One is what's called a provisional patent application. It's a less formal patent application. It basically gives you a year placeholder. You can say, hey, I've got what I think is a great idea. I'm going to go out and see how it does in the marketplace. It may take off and do wonderful, or it may bomb. And where I don't know, I don't want to invest in a full patent. So you do a provisional patent application, acts as a placeholder. That one's going to be a flat fee, at least for 2020 of $1,700. We're increasing our rates just a little bit for 2021, but it's right around that kind of a thing. If you're doing, hey, I want to do a full patent application, it's about $5,500. And so that kind of gives you those level sets. Trademark application, you're going to have a flat fee of $750. And when I say flat fee, that means both the attorney's time, all of ours included, as well as the governmental fees. And that was, the 30-second side. That was one of the things that always frustrated people. Is they'd always feel like it was nickel and dime, that they would get told one cost, and then it would always seem like it built on, and it was never ending. And so we did, hey, this is all inclusive. To prepare a patent application and file it, or prepare a trademark application and file it, it's at $750 for a trademark, and either $1,700 or $5,500 for, depends on the type of patent application.
Amazing. And any geographic limitations, or do you service the whole of America?
We do it all, or across all the U.S. So the nice thing about patents and trademarks, it's on the federal level, which means you can do it in all 50 states. And I have clients everywhere from New York, New Jersey, California, Oregon, Washington, D.C., Utah, Colorado, all over the place. And so we service everybody across the whole U.S. We also do international stuff. So usually the way international stuff works is we will, in different countries, we'll be the people that manage it. We have other contacts that are in other countries that will be kind of the boots on the ground, that will have them file and be the representative of those countries. So we're happy. We have clients that file all the time in the EU or the UK, Australia, Brazil, and all over Mexico, Canada, and we'll do those as well. And it's really just, we have our people that we have a good relationship with. They'll be the representative or the attorney in the country, but we also allow it to be managed kind of in a centralized location. So you don't have 5 different attorneys for 5 different countries.
And my last question would be, I guess, for anybody who listens to this from the UK, what can you do with an existing UK-based patent portfolio in terms of translating that into something that can be used readily in the US?
Yeah, so if you're on a patent, a well-drafted patent in the UK, you can generally file in the US. So you're always going to want to be careful. Usually, you'll want to file it in what's called a PCT application that kind of gives you that placeholder. You have to file it within a year of when you originally file your patent application in the U.S., and then that PCT application gives you a total of 30 years before you have to do anything in the U.S. But just be cognizant you have basically a year within if you're going to file foreign, you have to do something. But beyond that, they could always, if they had something in the UK and they're saying, hey, now I want to go into the U.S., they could reach out to us. A lot of times we can take what you filed in the UK or in the, in the EU. They want to make some tweaks, some modifications, and they want to We have to, put it in kind of the format and the style that the U.S. wants, but we can largely lift from what you've done, and it makes it a much cheaper price. That's a little bit depends on what it is as to what the cost would be, but we can greatly reduce that price. Trademarks are about the same. Hey, if you have let's say you had a company that you started in the UK, it's growing big, and now you're saying, hey, we want to enter the US market, we want to go there. We can generally take the same trademarks you filed there, file them in the US, and play off of those. So usually it's a pretty good kind of move over from the UK to the US.
Devin, I just want to say thank you so much for all your input and advice. It was really interesting. And as I say, I've sort of come from a place of ignorance, but it is to give people a look under the hood of what they need to do and where they might start this journey. So, again, just let people know where they can go to for that free consultation.
Yeah, and hey, first of all, that's a compliment. To make law industry interesting is a hard challenge in and of itself, because generally lawyers aren't known for being interesting. So I'll take that as a compliment. As far as people wanting to reach out, connect with us, I'll give you kind of 3 ways that they can connect depending on what they want to do. So one, as I mentioned, if they want to just do a consultation, they want to get a free strategy meeting where we sit down, kind of go through the questions they have or talk through the business and kind of get a strategy or a plan in place, just go to freestrategymeeting.com, all one word. And that's an easy way. That will link to a calendar, grab a day and time that works for you. If they want to just find out more about the law firm, find out about our prices, learn a bit more, we have a ton of tools and information on our website that they can just come and learn a lot more. That one, you can just go to Law with Miller. So law with, and then, all spelled out, Miller, MILLER.com, lawwithmiller.com. And that's the way to find out about a lot of our law firm. The last one that I'll throw out there is if they just want to reach out to me, they want to know more about my businesses, they want to be my next best friend, they want to just find out more about me or any or all of the above, they can go to Meet Devin. So Meet, MEET, and then Devin, DEVIN.com. So meetdevin.com. And that one links just to my personal calendar. They can always, if they want to ask about IP, they want to ask about anything else, I'm happy to chat, or anything else. That's an easy way to connect up with me. So those are the 3 easy ways to connect up.
Amazing. Well, Devin, thank you so much for your time. And yeah, I'll encourage anybody who's looking to go with a law firm that's sort of startup friendly to come your way.
Awesome. Well, I certainly welcome anybody reaching out, finding out more, and I'm always here to help.